Hey, what's up, guys? Today I'm going to be showing you an example of just how biased the courts are against debtors going through debt disputes with large financial institutions. Today we are dealing with a K.G. Neilson, Justice K.G. Neilson, who you will see is absolutely out of control. So just for a little bit of background information about the context of what's happening here, an individual disputed her debt and simply requested proof of ownership due to the fact that debts are bought and sold every single day. So this individual put a statement of claim into the courts against their bank, stating that they were trying to collect on a debt which they could not prove that they owned, and was asking the courts to verify ownership of the debt. So after the statement of claim went in, Justice Neilson issued a memorandum order, which means that there was no hearing and there was no trial. The Justice K.G. Neilson just decided that he was going to put together a memorandum and completely sidestep due process and not allow this individual to have a fair hearing. So you can see in this email, which was served on the individual on September 5th, they are stating that in order for this individual to receive a fair hearing, they have to pay $10,000 in security costs by September 6th. Again, they served this individual on the 5th, and they're ordered to pay $10,000 by the 6th, giving this individual 1 day to muster $10,000 to receive fair due process in the Canadian courts. I mean, how absolutely ridiculous. Then, at the end here, they say you should provide an affidavit evidence about why you should not be subject to the security for costs, why you should not have to pay $10,000 in order to receive a fair hearing. Now, this is absolutely ridiculous. I don't know any other cases where people are ordered to pay money in order to receive a fair hearing, especially when an identical case in substance was deemed not frivolous or vexatious by the same Judge K.G. Neilson priorly, in complete contradiction to his current statement. This goes against absolutely all the principles of due process. Due process and justice should be available to anybody, regardless of their financial status. So why is it that here in Canada, individuals undergoing debt disputes with their banks have to pay $10,000 just to receive a hearing? So furthermore, as per the order, this individual sent in an argument about why they shouldn't be required to pay the $10,000 security costs. And within that, it outlines the fact that they were not served the order until September 5th, with a demand that the amount be paid by September 6th, or the claim and defense would be struck. I mean, that is not reasonable whatsoever. The grounds for challenging the security costs is that they are unjust and unreasonable. The imposition of security costs in this matter is unjust and unreasonable, particularly in light of my financial circumstances. The amount required is disproportionate to the debt under dispute and her ability to pay. Access to justice. Requiring me to pay $10,000 in security costs effectively denies me access to justice. It would prevent me from continuing my defense and pursuing my claim in this matter. Procedural fairness. The order was not served until September 5th, giving me only 1 day to comply, which is unreasonable and violates my right to fair notice and opportunity to respond. Then, if we take a look at the response from the Alberta courts, they simply say that there's nothing they can do to assist you and that it's too late, you should just appeal the order, which costs another $700. So essentially, their plan here is to just pile court fees and sidestep due process onto this individual in hopes that they will turn around and run away. It doesn't make much sense as to why security for costs is required to simply have a debt validated. I mean, it states very clearly in Alberta legislation that debtors are entitled to the accounting of their debts upon request. But here we have Justice K.G. Neilson going directly against consumer protection legislation in Alberta and stating that in order to receive a fair hearing, they have to pay $10,000.